All right, good morning again. This is State of Georgia versus Colt Gray, 24 CR 594. We're here for a status hearing. Counsel for both sides are present. Mr. Gray is present. Few things to discuss. Let me start with discovery. Has all the discovery been made available to Mr. Allen?
Yes, Judge. We have received all the discovery that, from the DA, and they have been helpful in helping us open some of the files that are more difficult.
Okay. Anything left to serve, Ms. Brooks?
I don't believe so, Your Honor. Obviously, we'll have ongoing calls from the YDC that we would continue to give, but other than that, I don't anticipate us having any substantial new discovery.
Okay. So aside from any recorded calls that are obtained moving forward, everything's been provided?
Yes, Your
All
Honor.
right.
Right out of the gate, one of the biggest pretrial milestones is already checked off: discovery. That's the process where both sides exchange evidence. And in a case this high profile, it's often where major disputes erupt. Here, though, both sides are essentially telling the judge, "We've got what we need." That may sound routine, but in a serious criminal case, smooth discovery can dramatically speed up the road to trial.
Mr. Allen, previous counsel filed a motion to change venue. I wasn't sure what your position is on that.
Judge, in the event we have a jury trial, I would be adopting that motion. But I do think that we would need to consider an alternate location for any trial.
All right. So we're proceeding presently as though we are going to have a trial. Obviously, that can change, but so with Mr. Allen adopting that motion to change venue, what's the state's position?
The state does not object to a change of venue.
All right, I'll enter an order changing venue. I can tell y'all, in anticipation, I've reached out to a couple of other locations trying to find places outside of the Atlanta metro media. I got a fair amount of radio silence from some of those jurisdictions. Do you have any suggestions, Mr. Allen?
Not off the top of my head, Judge. Some of the places that I have had cases farther down south are relatively small jurisdictions, and I don't know that they would have a large enough jury pool.
Yeah, it's hard trying to get outside the metro Atlanta media circle and still find a place that's got the ability to host a trial like this. I know the state had recommendations before. Do you have any presently?
Did you catch that? The prosecution isn't objecting to a change of venue. That's a significant development. When a case receives intense media attention, finding jurors who haven't already formed opinions becomes a challenge. The court is now actively searching for a location where potential jurors are more likely to approach the case with fresh eyes. Question for you: do you think moving a trial truly helps guarantee fairness, or has major news coverage become impossible to escape nowadays?
No, Your Honor, I'm sure we'll have opinions on whatever you bring forward, but we don't have recommendations.
Well, I can tell you the leading candidate right now is Columbia County, which is part of the Augusta area. Their media is pulled from Augusta as opposed to Atlanta. The chief judge there said they're more than likely willing to accommodate and to accept us having a trial in their courthouse. They're doing some renovations right now that should be ready. I would like to have it scheduled in the fall. State still think about 2 to 3 weeks, or?
We do think this case will take less time than Colin Gray's trial.
Okay.
So I anticipate including jury selection being done within 2 weeks.
Probably in the third jury selection.
Yeah, maybe into the third with jury selection, but we do not think it would go a full 3 weeks.
Okay, Mr. Allen.
Judge, I would anticipate between 3 and 5 witnesses. One of them would take a substantial length of time, perhaps an entire day.
Okay.
So if their case is going to be a couple of weeks, then we probably need to be, 2.5 weeks. So.
Okay. Well, if it's okay with everybody, and I know I just now told you all, so you can sleep on it and get back to me, but I'll kind of move forward in some preliminary discussions with Columbia County to.
This is the part of a case many viewers never see, but lawyers live by: scheduling orders, witness lists, motions, jury questionnaires, discovery deadlines. Every major step gets mapped out months in advance. It may sound procedural, but these deadlines can shape trial strategy in ways that ultimately influence what evidence jurors hear and when they hear it.
To try and make arrangements. And again, some of that is going to be whether or not their courthouse renovations are on track, but they anticipate that it shouldn't be a problem. Okay?
And as a potential time range, I think the court just mentioned something in fall. I'm assuming somewhere from September, October range is what the court is thinking.
Yeah, I can tell you with their timeline with the renovations, if Columbia County is ultimately where we're doing it, we would probably be starting mid-October and then running through potentially into that first week in November. And I can, after I have further conversations with them, and if everybody's okay with that, if y'all don't have objections to that venue, then I can circle back with you guys and we can kind of iron out a time frame. But that seemed to work for them if they're going to host it. All right. As far as a scheduling order, have y'all had any discussions regarding a scheduling order?
Yeah, sure. Mr. Allen and I discussed kind of potential time frames based on a scheduled trial week and, like 45 days before trial, that kind of stuff.
Okay.
So we can, if the court wants us to, we can sort of fashion a proposed order based on like an October 10th date. And then that'll kind of give us a better idea of an actual schedule. Even though we don't have a specific time yet, I think we can go ahead and just say that date. And so it kind of the time frames are, motions filed 45 days prior to trial. We serve our witness list on them 40 days prior to trial. They serve their witness list on us 30 days prior to trial.
Notice how both sides are signaling there won't be a flood of pretrial motions. That's interesting because complex criminal cases often generate dozens of legal battles before a jury ever enters the courtroom. Here, the attorneys seem focused on a relatively narrow set of issues, which could indicate that the major factual disputes are likely headed directly to trial.
We serve voir dire questions 21 days prior to trial.
I don't know that I'm going to review voir dire.
Okay.
I did that last time, and I
Yeah,
don't think I'm going to do it again.
we're totally fine with that.
Okay, that's fine with me, Judge.
So those are kind of our suggestions, and then the defense served discovery 30 days before trial, which I anticipate y'all probably doing that beforehand. And that kind of would, I think, give everybody enough time.
I don't think our discovery to the state's going to be very complicated, Judge. Once we get all the pieces lined up, I'll give them immediately to the state, so that'll probably be a good deal of time before the trial, even well before 30 days. So I'm sure all that'll be ironed out long before we get down to a trial.
Okay.
And me and Mr. Allen discussed this before court. We don't anticipate there being a ton of motions. I do think there will be a Jackson Deno hearing, of course, potentially a motion to suppress, but I think that would probably be the extent of it.
Yeah, I'm anticipating somewhere between 2, maybe 4 at max motions that I would offer at this point. May not even do that many. But.
Okay. None pending presently that we need to address?
No, Judge.
Okay. All right. As far as the scheduling order, I am going to put a plea deadline in. I actually do that in essentially all my cases. It would be that last week of July. That's judges' conference, so courtrooms are available. We don't have any conflicts. I know that now Colt Gray is scheduled for that week as well, and I realize that there's got to be some sort of separation in the event Mr. Colt Gray changed his mind and wanted to enter a plea. If he was going to, my hope would be that we can just get victim impact testimony one time and separate everything else. But we can have further discussions about that if.
And I would probably object to that, Judge, and I understand wanting to be mindful of the victims' families and having them come back and relive testimony. But by the same token, Judge, I think there are some due process issues that would create. I would want to make sure that anything related directly to Colt were related only to Colt and not to any spillover from Colin. And definitely I wouldn't want them in the same room or in the same hearing. My question to the court would be that if you're setting a deadline for a plea, are you also wanting that to be the sentencing date?
Now we're getting into a fascinating legal debate. Defense counsel is challenging the idea of a plea deadline, arguing there could be due process concerns if a defendant later decides to plead guilty. The judge's position is more practical. Courts and taxpayers shouldn't spend enormous resources preparing a jury trial only for a plea to arrive at the last minute. This is one of those moments where legal rights and judicial efficiency collide.
If we decide to plea or are we bifurcating? My request would be to bifurcate the plea date from the actual sentencing date so that I could pull together all of my mitigation witnesses and have them targeted for one day.
So the problem with doing a plea apart from sentencing is, of course, it can just be withdrawn as a matter of right. So if we needed to split that week up, if people were objecting to the arrangement of just the victim impact testimony once, then we can do Colt Gray 2 days and we can do Colt Gray the next 2 days. And again, this is just in the event he changes his mind and doesn't want a trial. So you should anticipate doing the plea and the sentencing, whether it's the second 2 days of that week or whatever.
And just for the record, Judge, I've discussed this with the court before. I do have an objection to setting a deadline for a plea. I do understand that there's no absolute right in Georgian case law for a defendant to enter a plea. However, I do think there's a framework for argument, particularly when you go with the line of cases that have followed North Carolina versus Alford and their interpretation of the defendant's right to enter a plea, even if he does not think that he's guilty of anything. And some cases that have developed after that give us an opening for a due process argument. So I do think it would be a due process problem if the court refused to allow him to enter a plea. Following that, if he changes his mind, we're set for trial, and then he wants to enter a plea.
I think the issue is going to be a defendant does not have a constitutional right to enter a guilty plea. They have a constitutional right to a jury trial, but case law indicates they do not have a constitutional right to enter a guilty plea. Now, if you want to submit letter briefs or anything on that issue, that's fine. But I want to avoid a situation where we burden another jurisdiction to make all these arrangements to clear out their courtroom, summon their jurors early, and then, the eve of a guilty plea is entered.
On the surface, this hearing may seem like housekeeping, but it quietly answered several major questions. Discovery is essentially complete, a venue change appears likely, a fall trial window is taking shape, and the court has already begun addressing potential plea issues. The big takeaway? The case is steadily moving from preparation mode toward trial mode, and the next hearings could become far more consequential.
So if the expense and the time is going to go into arranging the jury trial, I want to plea early enough in advance that most of that can be bypassed, where we don't have to expend the resources, the time, and burden the other jurisdiction. So that's the reason for the plea deadline. But again, I'm happy to take letter briefs or anything on that point.
Just for the record, Justin, still objecting, Judge.
Yes, sir.
Thank you.
State, have anything?
No, we understand your plea deadline policy. We've been subject to it for a while now, so. The only thing I would say, I know that I believe Bexar County schools start that Friday, July 31st. So if Mr. Gray's plea is the end of that week, it's up to the board. I just wanted to put that out there.
My wife's a teacher. I understand the first week of school. But it's going to be during school regardless, so whether it's the first day when kids aren't learning anything or it's, the middle of October when they have exams. There's no good time to do it but summer, and we're not going to be able to get it in summer. So.
And we can do our best to if it's those last 2 days, Thursday and Friday, we can try to get the students in the 30th to testify if they want to give a victim impact.
Okay. Well, I'll follow up with Columbia County, kind of give y'all, based on the discussions with the chief judge there, give you guys maybe a little firmer timeline. Y'all can talk about the scheduling order as you laid it out. Submit that to me in Word. I'll, include any plea deadline information in it.
Okay.
Anything else we need to address today?
Not from the state.
I think logistically, that's it for now.
Okay. All right. Well, thank y'all.
Thank you, Your Honor.
Thank you, Judge.
Yes, sir.